Hello Live Law viewers, welcome to Courts Today by Live Law, your daily roundup of legal updates from across the country. I'm your host Urvashi Chauhan, here to keep you informed and up to date. Let us start with the headlines before we dive into the details. In the Delhi air pollution matter, the Supreme Court has directed the Air Quality Management Commission to consider allowing physical classes in schools and colleges. The top court has today dismissed pleas challenging inclusion of the words socialist and secular in the Constitution's preamble. The Kerala High Court has granted anticipatory bail to Malayalam actor Baburaj in a sexual harassment case due to 5 years delay in filing the FIR. The Supreme Court has constituted a special investigation team to investigate custodial torture allegations by women protesting against the Arjikar Hospital incident. The Allahabad High Court has come to the aid of a visually impaired candidate who could not fill the AIBE form due to error in his LLB results. The Madras High Court has ordered investigation into a matter after, surprisingly, the investigating officer said that she did not investigate the case and her signatures were forged. In the motor accident compensation case, the Supreme Court has awarded 15 lakhs as compensation for pain and suffering to a claimant with 100% disability. And the Delhi High Court has summoned ED Special Director after its counsel addressed the judge in an offensive manner with a loud tone. A Supreme Court bench comprising Justices Abhay Oak and A.G. Masi today heard the Delhi air pollution matter to consider if the GRAP 4 restrictions should continue in Delhi NCR. Last week, as the AQI in NCR crossed hazardous level, the Commission for Air Quality Management had imposed GRAP 4. As a result, all construction activities were stopped, trucks carrying non-essential goods and diesel-operated medium and heavy goods vehicles are banned, physical classes in schools have shifted to online, etc. In wake of the physical classes being suspended, last week, senior advocate Menaka Guruswamy had argued that it had affected the underprivileged sections for whom midday meals at school was an essential incentive and schools were a secure place for children and parents could go to work. The court has today directed the Commission for Air Quality Management to consider relaxing the restrictions on physical classes of schools, colleges and educational institutions in Delhi NCR. The court passed the order considering that a large number of students cannot avail midday meals due to suspension of physical classes. Also, many homes do not have air purifiers and hence there is not much difference between outside and inside air for such homes. The Commission is to also decide on continuation of physical classes for standards 10th and 12th. The Commission must take a decision in this regard by tomorrow. Further, the court came down heavily on authorities for not enforcing the ban on entry of trucks and light commercial vehicles to Delhi properly. Amicus Curiae senior advocate Aparajita Singh informed that 83 checkposts were surveyed and many posts were unmanned. She also said that the personnel did not have precise clarity of orders. The court thus directed the Commission to initiate prosecution in terms of Section 14 of the Act against the officials who failed to enforce the directives. Let me tell you here that this provision grants the Commission sufficient enforcement powers, including the authority to impose penalties and initiate prosecutions for violation of air quality norms. The Supreme Court has today dismissed a batch of petitions that challenged inclusion of the words socialist and secular in the preamble to our Constitution. These words were added as per the 42nd Amendment passed in the year 1976. Senior BJP leader Dr. Subramanian Swamy, Advocate Ashwini Kumar Upadhyay and Balram Singh were the petitioners who questioned the power of insertion of the words into the preamble during the time of emergency in India. According to them, amending the preamble is a constituent power which can be exercised only by the Constituent Assembly. Well, today the bench comprising CJI Sanjeev Khanna and Justice Sanjay Kumar observed that the amendment power of Parliament extends to the preamble as well. That date of adoption of the preamble does not restrict the power of the Parliament to amend the preamble. CJI Khanna said that after so many years, the process cannot be nullified. The judgment also explains what socialism and secularism means. Last week, if you remember, the CJI had remarked that socialism in India is very different from other countries. Here, socialism primarily means a welfare state and not against the thriving of the private sector. The Kerala High Court has granted anticipatory bail with stringent conditions to Malayalam film actor Baburaj in connection with allegations of sexual harassment. The complainant in this case came forward with the allegation after publication of Justice Hema Committee report, which revealed large-scale sexual harassment in the Malayalam film industry. The complainant alleged that the actor abused her in 2018 while she was working as a receptionist in his hotel in Munnar. The complainant further alleges that the actor raped her in his house in 2019, where he called her to talk about an opportunity in the movie industry. The survivor submitted that since she was separated from her husband, she did not have the courage to file the FIR. It was stated that she registered the FIR in 2024 after she got married again in 2023. The court noted that the FIR was lodged only this year in September after almost 5 years of delay, and the court was not convinced of the explanation provided by the survivor regarding this delay. Therefore, it granted anticipatory bail. While allowing the bail application, Justice C.S. Dias referred to the decision in actor Siddiqui's case, who was also granted bail recently by the Supreme Court on similar grounds of delay in lodging the FIR. The top court has today constituted a special investigation team to look into the allegations of custodial torture of 2 women who were arrested during protests that took place in West Bengal after the RG Medical College rape murder incident. A bench of Justices Suryakant and Ujjal Bhuya was dealing with the state of West Bengal's challenge to a Calcutta High Court order, which had directed CBI investigation into the matter. Earlier, while issuing notice, the top court had stayed this direction of the High Court. It had asked the state government to submit a list of IPS officers, including women officers, who can be included in a special investigation team to investigate this case instead of the CBI. Taking into account a list of officers given by the state, the court has constituted an SIT today. It includes officers not belonging to the state of West Bengal but serving therein. This SIT shall take over the investigation and submit weekly status reports to the Calcutta High Court. While passing this order, the top court today said that regular transfer of investigations to CBI can have a demoralizing impact on senior state police officers, and that it should not be presumed that senior officers allocated to West Bengal cadre are incompetent or inefficient to hold a fair and independent investigation. In the next update, let me tell you, the Allahabad High Court came to the aid of a visually impaired candidate who could not apply for the All India Bar Examination 19 in time. This was due to an error in his 5th semester examination result caused by his university. Though the university rectified the error and declared the candidate passed, the petitioner, due to the said error, could not submit the exam form in time, that is before the deadline, which ended on 15th November. In view of this, a bench of Justice Saral Srivastava directed the Bar Council of India to permit the petitioner to submit an application form for appearing in the exam within 1 week and to allow him to appear. The AIBE 19 is scheduled to take place on 22nd December. The Madras High Court has ordered a fresh investigation into a case after investigation officer informed the court that she had not investigated the case and her signature in the final report was actually forged. The court was hearing a petition filed by P. Venkatesan, who had initially filed a complaint against some persons for public obscenity, causing physical harm and grave threats of harm or death. Venkatesan's grievance was that the investigation was not being conducted properly. The police had filed its final report and the magistrate took the cognizance also. Venkatesan had approached the court now to set aside the final report and transfer the investigation to the CBCID. In order to verify the facts of the case, the court called the investigating officer. To the court's surprise, the officer stated that she had never investigated the case nor filed the final report. She said that she came to know of the entire facts only upon receiving a summons from the court. Noting that the case was quite unprecedented, the court was convinced that the investigation had not taken place and the entire criminal proceedings was fabricated. Therefore, Justice Anand Venkatesh directed the CBCID to take over the case. The court said that the investigation should not be limited to only the issue of the case, but also to find out as to who prepared the earlier police report. Calling it a serious issue, the court added that after the truth comes to light, independent proceedings need to be initiated. While dealing with the case of a motor accident compensation, the Supreme Court has allowed the appeal of an injured appellant and awarded a compensation of 15 lakhs under the head pain and suffering, even though he had prayed for 10 lakhs. The appellant here was travelling in his company vehicle when it collided with a container lorry being driven negligently. He suffered 90% permanent disability. The Motor Accident Claims Tribunal took his functional disability as 100% and held the insurance company liable to pay more than 58 lakhs with 6% interest per annum. Aggrieved by this order, both the appellant and the insurance company appealed to the Karnataka High Court. The High Court enhanced the amount of compensation to 78 lakhs. Again, challenging this order, the appellant approached the Supreme Court. The Supreme Court has modified the award of compensation on two counts: future prospects and pain and suffering. Under pain and suffering, courts compensate victims for the physical pain, emotional distress, and psychological trauma they endure and loss of quality of life. A bench of Justices C.T. Ravi Kumar and Sanjay Karol noted that there was no dispute as to the injuries sustained by the appellant being serious and their effects on his life being long-lasting. The court has ordered that a total amount liable to be paid to the appellant will be 1,02,29,000. And lastly, a Delhi court has summoned the Special Director of Enforcement Directorate after its counsel addressed the judge in offensive and derogatory manner with a loud tone. Special Judge Jitendra Singh of Rouse Avenue Courts was hearing the money laundering case involving Karnataka Deputy Chief Minister D.K. Sivakumar and other accused persons. An application was moved by one of the accused seeking release of the loose sheet pages along with digital devices. His counsel said that ED was deliberately not releasing the articles just to harass him, even though the matter was already quashed. The counsel appearing for ED submitted that he had specific instructions from higher-ups to seek adjournment for 15 days. According to the order recorded by the judge, on being questioned about the necessity for adjournment, the counsel apparently said that the court can do as it likes in an offensive and loud tone. The court observed that it was not the only instance where the counsels for Enforcement Directorate have behaved in such a manner. Therefore, the court has directed Special Director of Enforcement Directorate to remain present physically and said that the presence was necessitated in order to initiate appropriate action for upholding the dignity of the court. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button at the below of our videos or by becoming a member at just 89 rupees per month.